Hello, my name is Mike Gillespie. I'm the Managing Director and co-founder of AdventIM. I have the portfolio for cyber strategy and research at the Security Institute, and I'm the Vice President of the Cyber Intelligence Select Committee at CSCSS. Some of the areas we will look at include the reasons you may start monitoring, employee behaviour, disciplinary offences, compliance with statutory breaks such as long-distance driving, the difference between snooping and monitoring or surveillance. Your employees have a right to privacy, and knowing the actions you can legitimately take that do not venture into snooping is vital, not only legally, but to maintain the trust of employees and for your own integrity. How monitoring is affected by the Data Protection Act and the Information Commissioner's Office guidelines. Legal requirements around how monitoring may be used are quite clear, so make sure you are familiar with them. How to manage resulting data from various sources, sometimes generated for non-monitoring purposes. From an employee perspective, it could still be called snooping, so make sure you know exactly what you are collecting. And we will also look at CIA, which is not what you may think, but is a helpful guide to data protection. So there are a range of reasons management may decide to monitor employees. There are also a wide range of means with which to carry it out. Some of these areas may not be considered monitoring in the classic sense, but are in fact just that. It doesn't matter whether or not an organisation is acting upon the resulting data. It doesn't need to be actionable or be used by HR or associated channels. It is still monitoring. There may be disciplinary matters, such as excessive personal use of phones, or of the internet, or viewing inappropriate content. There are a range of inappropriate behaviours both on and offline that may need addressing, or at the least investigating. Perhaps things like misuse of company vehicles, for instance. All are valid reasons to consider monitoring. However, doing this incorrectly or in a cavalier or ill-informed manner is a minefield for an employer, and can be far more damaging for the employer than for the employee who is being accused. So what is the difference between monitoring and snooping? A HR department's idea of acceptable monitoring may differ from an employee's, particularly if that employee is facing some kind of disciplinary procedure. Employees have a reasonable right to privacy, and in actual fact the ICO is very clear on the subject. Its guidelines say that monitoring must be approached with a spirit of honesty and openness towards employees. This means monitoring cannot take a blanket approach, just in case someone does something wrong. It cannot be covert. Employees must be made aware of any monitoring. It cannot take place if no education of policy has been given to employees, and all resulting data must be handled strictly within the Data Protection Act articles. A spirit of openness towards employees then. So what does this mean? It sounds like we ought to know exactly what it means, but it's worth exploring a little further. Not only do you have to ensure affected employees, and it must be affected employees as opposed to all employees, which would of course be snooping, are aware of monitoring. You must also make sure that they understand why you are monitoring and be totally clear on what the process is. Clearly, if this is going to be part of a disciplinary proceeding, it is vital and it must be adhered to. They should also be told precisely what systems their employer will be monitoring. In other words, they should be informed if their employer is monitoring their phone calls. They are also entitled to know who is responsible for the monitoring and who will have access to the data generated by the monitoring. So for instance, if we use the phone usage example again, the employees should know who is recording their calls, and they should know who will be permitted to listen to them. They are also entitled to know how the resulting data will be managed and eventually destroyed. So the employees should also know that their data will be stored in a password-protected network area, accessible by the HR manager alone, and that their data will be securely destroyed after the conclusion of the proceedings. If these areas are not addressed, employment tribunals may well result in a negative outcome for the business, and potentially could also attract the attention of the ICO, which is rarely pleasant. So, let's look at some examples of handling data that has been collected on individuals during monitoring for disciplinary purposes. In our example here, consider the figure as being the IT manager. The data has been collected on an individual. In this example, it's door entry data, timesheets, CCTV footage, tachograph data, internet activity, and recordings of phone calls. Is it appropriate for the IT manager to collect this data? Let's put the question another way. It may be appropriate on a functional level for the IT manager to be collecting this data. However, in the spirit of the ICO guidelines, is it appropriate for the IT manager to be accessing the data once it has been collected? No, it probably isn't, and that is how the ICO would view it too. In this instance, if an employee who was potentially facing dismissal were to take this to a tribunal, there is every possibility it would be a negative outcome for the employer. The IT manager is not an appropriate person to be reviewing this information. To make sense of how the situation should in fact be handled, we need to discuss CIA. No, that isn't the Central Intelligence Agency, although it is pretty intelligent and probably ought to be common sense. CIA in this circumstance means confidentiality, integrity, and availability. And these are vital components to building a successful and compliant monitoring policy. Limiting who has access to the data that has been generated during this inquiry means that there can be no breach of confidentiality. In our example, there is no reason why the IT manager should be able to hear phone calls made or even see a list of calls. There is no reason why the IT manager should view timesheets outside of any normal timesheet sign-off for their own staff. Confidentiality includes word of mouth. Imagine the repercussions if an employee is going through a dismissal and their colleagues have already found out what is happening. And authentic and complete data. It sounds obvious, doesn't it? So data should be correct, of course, but can it be trusted and relied upon? So for instance, if a document has been created and someone takes a copy of it, a newer version may exist which completely negates the content of the original. Version control is one way around this. If, as in this case, we are talking about a person's livelihood, it becomes even more vital that this aspect of security is strictly observed. Which brings us to availability. Can the person who is supposed to be seeing this data see it, when and how they need to see it? Again, sounds obvious, doesn't it? Imagine, as in our hypothetical case here, the IT manager has saved a huge amount of data relating to our invented disciplinary case. However, the IT area of the network is not available to non-IT staff, and the IT manager has now gone to Portugal, leaving the key data for the monitoring safely hidden away and inaccessible for the disciplinary hearing. Point 1. The data is no longer accessible. Point 2. If someone else from IT were to access this data in order to help out management for the disciplinary hearing, we are potentially compromising our confidentiality, the C in CIA. So again, the employee would have good cause for complaint. When it comes to CIA, wrong, incorrect, or absent information could actually prejudice the outcome of a hearing. So it is equally important to all parties that CIA is observed in monitoring, especially in disciplinary cases. So, let's look at our example again. Would it make more sense for the data to be accessed only by HR and pertinent management? Employees would also need to know who is accessing this data. Sure, IT will be involved in harvesting the data, but is it appropriate that they have access to it? CIA is the guide to how you should manage this important and sensitive data. Don't forget, sometimes there are emotive issues involving highly controversial or sensitive matters. So the person reviewing any resultant data also needs to be in an appropriate setting. For instance, If someone is habitually surfing on pornographic websites and data is collected on what they are viewing, it is not appropriate for the offensive material to be reviewed in a busy office surrounded by the people who would have been offended by this in the first place. Also, they should be aware of correct procedures. For instance, as in this example, not be making copies of everything that has been viewed, as this in itself could also be an offence, especially if it's something like child abuse. So to sum up, the ICO is clear on what is acceptable. CIA provides an excellent framework to hang the process on. It may well be appropriate for someone to collect data, but not be permitted to access it. If you want to read more about the ICO guidelines on employee monitoring, you can find the link on screen now. Here you will find the quick guide for employers, which is useful for any organisation, but may be particularly helpful for small and medium enterprise businesses. So in summary, use all of the guidance available to you. It will mean not only will you enjoy the continued cooperation of your employees, but your monitoring will be effective and well planned and executed and on the right side of the law. Be clear in what you are trying to achieve, and be transparent with employees about what activities you are performing and the purpose for which they are being performed. Be very careful with your outputs and what may be revealed in isolation or through aggregation. It is your responsibility to protect this information, and always remember your employees' right to privacy.